I'm Bob Cease. I'm the new Assistant Director at the International Student Scholar Services Office. I've met most of you, some of you I haven't. But I'd like to formally introduce Attorney Kathryn Karam. She's a former Trinity grad and majored in Chinese and went on to law school. So if any of you here are majoring in Chinese and think you can't go to law school, here's perfect. She worked with two prominent firms in Houston, Gordon Kwan, Burdett, what's the last one? Perez. They're a really good firm. They did my mother-in-law's green card and my father-in-law's green card. No, actually, and also, actually one of the best firms, and also Foster Kwan, two of the best firms probably in the country with regard to immigration law. So if you're going to learn immigration law, those are two great firms to work for. And she worked for both of those firms, and then she went out and she formed her own firm. Now she's president of Kathryn Karam PC, the law office of Kathryn. So she has her own law office now and offers services in different languages, two Chinese dialects, Spanish and Vietnamese. And she's had a lot of involvements in social circles as well as professional circles. And if you'd like to highlight some of this, what you do so.
Sure. Well, yeah. So just to let everybody know, as Bob said, I did graduate from Trinity. My major was Chinese. I spent a couple years off and on in China after I graduated, and I had put off law school a couple times to do that. Finally went to University of Texas and got my law degree. And I knew in the middle of my studies at UT that I was going to work in immigration because I started working at a nonprofit, and even though I didn't understand at all what I was doing, because it's such a steep learning curve, in my opinion, to get into immigration, I knew that it was a meaningful field for me and that I have to do things that feel like they're meaningful. If I'm just fighting with someone over a bunch of money, it's kind of hard for me to get interested in it and really want to do a good job. So it was a field for me that I could really get into and I could really enjoy. And I think another thing that fueled the interest is that having been a student in the Chinese program and going to China a couple of times, maybe 2 or 3 different programs that I was involved with being in China, I've learned what it was like to be someone living in another place and be picked out immediately and criticized or ostracized or laughed at or yelled at in a language that I didn't always understand. And I kind of said, you know, this happens all the time in the US to people. Everybody gives me a pass in China because my Chinese is not good because I'm Western, but nobody does that in the US. We're kind of hard on people. It's kind of like get in where you fit in, and I could understand that. And so I think all those things came together and they brought me into the field that I'm in now. And as was mentioned, I was at Kwan, Burdett, and Perez, which became Foster Kwan. That firm is no more. Mr. Foster and Mr. Kwan have their own firms. And those gentlemen are still people I respect a lot. But I opened my own practice because I had gone the corporate route for a bit and gone to a worldwide firm that has 1,800 attorneys all over the world and never got to meet my clients, never got to talk to anybody. Everything was done by computer, and there were no unique situations that I ever saw. There were no unusual things, which had become my specialty, was to take the things that everybody thought couldn't be done or that were really difficult or that had gone 20 years without a resolution and try to finish those off. And I never got to do that, so I knew it was time for me to get to that place where I could be around people and talk to people and offer that expertise that I'd grown. So I'm board certified in immigration in Texas. If you're board certified, you're one of 160 in the immigration field who have that distinction. But I say that only because it's really my specialty. It's all my office does. So it really is my passion, and it's something that I'll be doing for a long time. This is part of my team. We actually have a couple more people on board now, so this isn't the full group. But I just wanted everybody to know this is us. This is my group, at least part of them. So, you know, as international students, I kind of made this presentation jumping right from who we are into the nitty-gritty of all these things. You know, I don't know where you guys are beginning, so if there's a different place for me to start that makes more sense to you, it's fine with me. This is the first time I've come to talk to Trinity students. And so I was trying to think about, in you guys' experience as international students, what are you going to need to know and where are you going to go after this? How many of you guys are on F1 right now? Is pretty much everybody here? Okay, so almost everybody here is on F1. So You guys may know about this already, and this might be review for you, but I wanted to bring this up because this is a good starting point for you guys. I'm not just gearing this toward people on F1. I want to talk to people who are not on F1. I want to talk to people who are, things I'm saying will have to do with other visas, will have to do with undocumented individuals. You may know some people on campus who are undocumented students, or you might know some people in the community who are. That's fine. I have things to say about that too. But I'm going to begin here with this part, because most of you may have heard about this already. So, you have this concept of optional practical training for students. These are the basic guidelines of it. The folks at Trinity may have, at the International Students Office, may have gone over this with you. You generally have to be a student that's a full-time student in good academic standing for 1 year before you're going to qualify for this. Maintaining your valid F1 status, generally you guys are going to be able to do that. This becomes an issue for students who don't go to school and maybe have a gap of several months that they didn't show up for school and they go out of the CVIS system, or work without authorization. Maybe at that point you're no longer maintaining your F1 status. I don't know that that's really an issue for you guys, but you have to do that. If you're going to be given OPT, it's going to have to be for work that's related to your study, and that can, that's a fluid definition. I think there are schools that, there are all kinds of programs that can be related to your field of study for different reasons, and the International Office usually assists you with making that determination and authorizing it. But there are two types of OPT that you can get. So one of them is while you're still finishing your degree, and that's what we call pre-completion. You're still in school. You can get up to 20 hours per week to be working on OPT. And then there's the post-completion OPT, which I see more commonly in my field. This is the 1 year of OPT that you get after you complete your degree. And I see this a lot. We'll talk about this a bit later, that the post-completion OPT comes into play for other reasons. But that's going to be 1 year of full-time employment, provided you apply for authorization for it after you complete your degree. And your international office probably has a program in place to talk to you about that when you're completing your degree. So as we said, in your pre-completion context, you have an application available to you at every level as long as you've completed the 1 year and you're maintaining your F1 status. And your school provides the I-20 that shows your authorization, and your school generally will assist you with any CVIS system or I-20 related issues. With your OPT post-completion, you're going to be applying for a work authorization, and you're not going to be authorized to work until you have that. So you need to work with your school office to be sure you get your application out as soon as you can, so that you get that document in your hand, that card that shows you're authorized to work for that year. It can take 90 to 120 days to get it. So as I said, as soon as you're able to do that, you want to go ahead and file for your post-completion EAD. And some of you may qualify for a STEM OPT extension. This is a new concept in the last 5 years that came out to help companies that wanted to hire graduates who maybe got their post-completion OPT, maybe tried for some kind of work visa, couldn't get it for whatever reason. We'll talk about that in a moment. And they wanted to give companies an option to keep people that they wanted on board, and this is what this was for. Hi guys, if you want to join us, come on back. Come on in. No problem. Take a seat. We're barely getting started, so your timing's okay. Yeah. So for you ladies, I just want to mention, we talked a moment ago about optional practical training. I had asked at the beginning who here was an F1 student. Most of the group was, mentioned that they were at that point. So I started off talking about optional practical training, and I'll go into some other things too. This presentation isn't just for F1 students. I'm going to cover a lot, but we were talking about OPT. You can get it while you're in your period of study, or you can get your 1 year of post-completion OPT after you complete your degree. Your office, your international student office, will be able to help you with that. But we talked a little bit about that and the qualifications for it, but there is also a 17-month STEM field OPT extension that is available. STEM meaning science, technology, engineering, mathematics. For those of you who didn't already know, maybe you already did. But as I was just saying, this program, this 17-month extension, was developed because there were a lot of people who wanted to go from F1 OPT maybe to a work visa, especially H-1B, And there's only so many H-1B visas available every year, so if they couldn't get those, and the employer wants to keep them, what do? So this began about, I want to say 5-6 years ago, as a way to give these students another 17 months of OPT employment authorization. And you know, there are guidelines for this OPT extension. As I said, your degree has to be in a STEM field. That's key. This doesn't happen if it's not. Your employer that wants to get you this has to use the E-Verify system. That's a requirement. And that is an online-based system through which they can check your authorization to work. So they have to be one that uses that. Not every employer does right now. So it has to be one that uses that. And you cannot have gotten this 17-month extension before. In other words, you can't do this over and over again as long as you have this degree and your employer uses E-Verify. This is a one-time thing. But the reason it's really good is it does give you another almost year and a half to try to do other things, to try to line up something else if you're really shooting for a work visa and it didn't work the first time. So it's been a really good thing where people qualify for it. If your employer is a really big company and they have you're in the San Antonio or Houston or Dallas branch of it, and they don't use E-Verify, in Texas right now we're not required to yet. Employers are not absolutely required to, but there are other states that are. I want to say Arizona is one of them. So if they have an office in Arizona, they might want to move you there if they really need to use this program. So that may be something you have to look at if you need to use this. But it is there, so it's good to know. The process for applying for the 17-month STEM OPT is that you're going to get a new I-20 from your office. You're going to have to apply again for another employment authorization card, just like you will do when you complete your degree and you're going for your 1 year of post-completion OPT. And you can continue, this is interesting that they did this, it's helpful. You can continue working on the expired employment authorization card you have from that first year after you complete your degree for up to 180 days while your extension for 17 months is pending. As long as you really were in post-completion OPT and not something else, like assuming you actually were coming out of post-completion OPT to apply for this and not going from some other situation, and you filed the extension before your current OPT expired. So if your current OPT lapsed and then you filed, this provision of working on the expired employment authorization card wouldn't work. So this is really encouraging you to go, if you're going to do this, if your employer wants to do this, you want to get on it as soon as you can and before your first post-completion EAD is expired. Pretty much everything we do in the immigration world is geared toward pushing people to hurry up and do things while they can or should, which sometimes is a great thing, but sometimes it's tough to keep up with. Some of you may have also heard about curricular practical training. This is only for work you're going to do prior to graduating, whereas your OPT usually can happen for 1 year after you complete your degree. This is only while you're in school. And yes?
So I was just a little confused with the pre-completion CPT. What's the difference? Like, to me, sounds like
sometimes they look exactly the same. You know, I think that programs were intended to be different, but really with the pre-completion and CPT, they usually look exactly the same. So it's hard to know. It's generally the difference is your school's annotation. Because most of the students that I've worked with that use one of these or the other, even the Immigration Service can confuse it and ask me for proof of pre-completion OPT when there is none and there's only CPT. And it's hard to understand why they made those two different things, why they don't just use OPT for post-completion and CPT for when you're in school. Some things, as you'll see, don't always make a lot of sense with the immigration world. And so those of us who like the puzzles and the challenges, I guess, it draws people like me to it, but this is only going to be before, like I said, before you complete your degree, before you complete all the units required for your degree. Again, just like pre-completion OPT, you're maintaining F1 status. It's related to your current field of study. This one, I actually think that the maybe OPT is a little less stringent on requiring a specific approved job offer. That may be the one little difference, but generally it's not. You usually have some kind of offer to go work somewhere. And that's why your school will either authorize pre-completion optional practical training or curricular practical training. So really it looks a lot the same. It ends up being a lot the same. So you make a great point that why do we have these two things? But this specifically requires an approved job offer. but as you mentioned, it's very similar. But that's what, when you see that CPT, that's what that means. And one more difference actually is that you could theoretically do full-time employment on CPT, where OPT is pre-completion OPT is 20 hours a week. So I guess that actually to me is the key right there. Your pre-completion OPT is you're only going to be able to do 20 hours a week if you do that. Whereas with your CPT, if it really is related to your work, you could get full-time authorization. It's hard to imagine being a full-time student and working full-time, but I did have one student who was in a master's program full-time, and the city of Houston was interested in having him on board, and there was an arrangement where he was able to do a full-time workload because it was directly related to his advanced degree. So that's an example of where you might see something like this. Again, you have a completed I-20 to show that the schools approve this. One thing to watch here for people who happen to have this situation come up, if you have 12 months or more of full-time work on CPT, you don't get the post-completion 1 year of OPT. So if you're counting on that 1 year of optional practical training after you complete your degree to try to give you a chance to find a potential sponsoring employer and apply for a work visa, you are not going to get that if you have 1 year of full-time CPT. A lot of people don't end up with 1 year of full-time CPT because it's hard to be full-time employed for 1 year while you're going to school. But if by chance, like my prior client, you have that situation come up, you really want to be careful for that, because if you're counting on that year of OPT after you complete the degree and you do that, it won't happen. So we got to watch for that. Did you have a question back there?
Yeah. Does that only apply if you have a full year of CPT?
Yeah, it's 12 months of full-time,
Okay,
yes.
well, what if you have less than that?
Then this provision doesn't apply. So you could have a few months of full-time CPT and still qualify for post-completion, because the regulation specifically says 1 year, meaning 12 months of full-time CPT.
Okay.
Yeah, so if you had a problem with that and you came to me and asked me, what do I do? If immigration said you don't qualify for this or something, I would try to argue with them that you do. That's because it can happen that sometimes they disagree, and that's what you do if you run into a situation like that. You had a question?
Yes. Can you have 12 months of part-time CPT?
Yes, because again, the regulation says full-time is what will bar you. So if you're on part-time CPT, yes, it's okay.
And you can push it to more than 12 months right now?
I think I don't remember anything in the regulations that says you can't. So I think you could be able to do that. And if you ever, if there's ever any assistance needed with anything, of course I'm available. You know, usually your office will be able to help you with it. But if there's ever anything that's outside of that, you know, of course, I'm here. Okay, so that is CPT. I had this, but we kind of jumped ahead into some comparison. With obviously CPT is while you're completing your degree. We're going to talk in a second about OPT and how it's a transition to other visas that you might try to get so that you can stay in the US and continue working. So one of the biggest things, in my opinion, is that with OPT, a lot of students are going to try and get H-1B visas when they complete their degree. And there is a cap-gap provision that I'll talk about in a second. CPT is obviously during the time that you're not yet completed your degree, so there is no cap gap that's going to bridge any time between completing your degree and getting an H-1B if you do go that route. That's one. There's no filing fee for CPT. There is a filing fee for getting your OPT work authorization. Again, OPT has that 17-month STEM extension that is available to it. CPT is only when you're in your degree program. Doesn't have that extension after your degree is done. There is no employment authorization card you apply for, so it makes sense that there's no cost for applying. Whereas in OPT, you're going to apply for an actual employment authorization card, and there is a filing fee. So those are some of the differences that you'll be able to see with these programs. But I feel that we're probably jumping ahead a little bit into the ideas that I'm going to be talking about in a second when you get through with your degree, and then you're thinking, what else can I do to try to continue working because I want to put my degree to use. So we're going to talk about that in a second. This was just some things I wanted to mention. I don't want to forget to talk to you guys about stuff to keep in mind. There are plenty of caveats. I could talk all day about issues that you have to watch for, but here are a few that I can think of for you guys. You know, if you've got, for example, a post-completion work permit for optional practical training, these employment authorization cards, work permits, we use those words interchangeably. if you have one of those and you've got a job offer, you want to be sure your employer is aware of the processing time. Because if they want you to start now and you don't have that employment authorization card in your hand yet, you're not yet authorized to work. So if you've completed your degree and you're still waiting on that permit, you want to be sure your employer understands that you need that first before you're going to be authorized to work. So that's something to keep in mind. Are they using the E-Verify system? If they are and you've got a STEM field degree, that may be something to keep in mind in case you need the 17-month STEM extension. Some employers, because they're so new, when you have smaller companies in particular, if they're really new to checking employment authorization and things like that, they may not be aware that you're actually still in school. And they may not be aware that you need to figure something out for when you complete your degree. So knowing where this employer, if it's curricular practical training or it's pre-completion OPT, you're still in school completing your degree. If your employer doesn't know what all that means and they're not thinking ahead about what they may have to do to keep you on board, it's an important conversation to have with them. I advise a lot of people who are not sure how to approach their employer and say, you know, I'm going to need this. And I tell them to call me, just tell them I need to do something about this, and can you talk with this attorney I've been talking to about my case and figure out what you're willing to do or not do. It's not necessarily something that I feel, this is my opinion as somebody who's been doing this for 7+ years, I don't feel like the employee's job is to sell the employer on, you know, apply for my visa for me. I think there may be, there's an aspect of that that goes on, but I think as far as the employer understanding what they're doing and everything, it's really important for them to talk to someone in this field because there's a lot of information that is involved in work visa petitions, and most attorneys will say at the outset to the employer, if I do this, I'm representing you and your employee. And so it's unusual in the legal field to have an attorney representing two different parties, but this is one of the times that it happens, and the reason is if the employer and the employee are not agreeing that this is what we're going to do, this is what we want, the attorney is going to back out. And so if the employer says, I am not doing this, I cannot help with this, and then an employee comes back to me and says, didn't you, aren't you going to, I have to tell them, I'm sorry, I can't represent you because you are not agreeing on it. So I'm mentioning this about, is your employer aware of all of these things? It's a really good idea to, if they're not, or they don't understand, or they're not sure what they can or can't do, to just start the conversation and bring in a third party, because that's what the attorney really is in this type of situation, is this third person who's trying to help two different people who are agreeing to do something. So when you run into that situation where they're going, well, when this thing expires and you're done with your school, what are we going to do? That's a good time to say, well, can we talk about that? And after that, you want to call somebody and have a discussion about it, see what you can do. So I just want to mention that because I'm always surprised how many people ask me, what do I do once I say to my employer, can we do this? And they go, well, I don't even know what it involves. I would think at that point they'd think, well, let's go talk to someone, but they're always kind of hesitant. So I want to mention that to you guys. One thing too is depending on the structure of wherever you might be working, excuse me, your employer might already have a whole department designated to this, dedicated to this. If there's a large company, it's very likely that they already have a department that handles it anyway, and you won't need to go to someone outside of that structure. So they may have someone that you can already talk to about what their policy is, because every company, especially the larger, more organized companies, are going to have their policy about, we will do this, we won't do that, we can offer you this, we do pay for this, we do not pay for that. And so knowing that and going into it is good. It might affect your decision to work with them or not. It may be a really good thing. But it's good to know if they already have someone designated to do that. I put, is the company willing to sponsor you for an H-1B on here, because that's generally something that comes up for a lot of you guys, is that when you're getting out of school, what visa options are available to you, and that's the biggest one that I find affects students coming out of a US degree program, and we're going to talk about that. But just asking, is that something you're able to do? If it's a small company or they're new to this, they may say, I don't know, I don't even know what that is. And it's okay that they don't. That situation doesn't bother me, it doesn't scare me. I've helped a lot of small employers who wanted to keep a person on board and wanted to know more about what they needed to do. So again, bringing that up and having that conversation, I think, is an important thing. Okay, so we're going to, as I mentioned, the H-1B visa is a big deal for a lot of people who are graduating and completing a degree program, and they're wondering, what can I do to continue putting the degree I just got to use in the United States? I'm not ready to go somewhere else right now. So I want to talk about applying for, I said right there, here are some things to keep in mind when applying for an H-1B. There are actually more than just H-1Bs available. I'll talk about some of these later. But since the H-1B is the biggest one, I want to go into that first. For you guys, I don't know how many people have heard or read about H-1B. Have a lot of people thought about this or heard about it? Some have. Okay, good. So, because it is a big deal, I'm going to give you a basic overview and then give you a little more detail about it if there's any questions or anything's not clear. Again, this is the first time I've talked to Trinity students about this, so feel free to raise your hand or ask. But generally speaking, with an H-1B, a person applying has to have either a U.S. bachelor's degree or the equivalent of it. And the equivalent of it could mean that they got a degree in some other part of the world, or maybe they have some education and some experience, and together it equals a U.S. degree in a field. And so if it's not, you guys do not have the equivalency problem if you're completing a degree at Trinity, but for anybody who's trying to use their education from somewhere else and or their experience, there are companies that evaluate your credentials and can go pretty deep into explaining why it's equivalent to a U.S. degree if you have to do that. Again, that might not apply for you guys, but if you have friends who are wondering about that, I send my clients' credentials to companies that evaluate them impartially and then send them back to me and we use them. So that's how that works if you weren't in a U.S. degree program. You have to have a job offer for H-1B purposes. It is not a thing that you can sponsor yourself for. So you have to have a job offer, and it has to be in a specialty occupation, and that's a legal term. Nobody outside of my field really knows what that means. It's a term they made up for this. But what it really generally means is the job has to require a degree in a specific field. So, for example, engineer, specialty occupation, it requires a degree in engineering. There's very few places that are going to hire an engineer that doesn't have a degree in that field. Public school teacher, generally you have to have a degree in a general field and be able to be certified in a specific one to teach in a public school. That's very common. Accountant is a common one. Attorney, I've seen people sponsor attorneys for H-1Bs. Then you get some specialty occupation issues with cases where it's not that clear whether the job actually requires a degree or not. I've handled a lot of those. I feel like I've seen that argument a lot. So if that specialty occupation issue that the job requires the degree is not clear, to me that's the number one thing that immigration comes back to us and requests more information about, is that particular issue. The employer, as part of this H-1B process, the employer has to agree to pay a required wage as determined by usually the Department of Labor in the United States. They might use other wage information from places other than the Department of Labor, but generally that's where it comes from. And they will go into a Department of Labor portal and certify this is the person, this is the job opportunity, this is what we agree to pay the person. They do certify that to the Department of Labor. They have to keep a public access file. This is not stuff that you guys will necessarily be involved in per se, but I want you to just be aware of this, that when an employer is going through this process, they're going to be keeping a file with all the information about their attestations to the Department of Labor and the wage they agree to pay and the location or locations where you would be. And that all has to be kept there. They can be inspected by fraud unit inspectors who will try to see if they're lying about what they pay or where they're putting people. And so they do have to keep a file about that and make it available to anybody who requests it. That's one part of it for the employer. The biggest issue that you guys have probably read about, if anything, is that an H-1B visa number has to be available when you apply. There's a limited number of H-1B visas available every year, and so knowing whether there's one available or not, it's a big deal. But we'll talk about that number of limited visas in a second. Let's continue with the overview. An H-1B is generally given for 3 years. It can be given for less if the Immigration Service doesn't think you really need 3 years of time because the employer is indicating that they need you for a year for this one contract. So it could be less than a year, but it's going to be up to 3 years, and you can do that twice. So you can get up to 6 years as in H-1B status. And so there are a couple of exceptions to that, but generally speaking, you're going to get 6 years on H-1B. Another thing you guys want to remember is that these are employer specific. These are not visas that allow you to work anywhere. They're not like your post-completion OPT where you can work anywhere with them. These are specific to the employer that sponsored you for this H-1B. So if another, you do have the option to port. This is what we call it when somebody moves from one employer to another. But the new employer is going to need to file a new H-1B petition to change you over to them before you start there. And so you can't just move around all over the place with H-1B. It's employer specific and it's location specific. If your employer moves you to a different location, there may be additional things they have to file. It's not that hard to do, but they need to know that that's their responsibility, that if your work location changes, they may need to update their records. Yes?
Those changes are within the same 3 years?
Whether they're within the same 3 years or not, yes. So even if you've got 3 years of H-1B, if your employer is going to move you to a completely different location, they're going to need to do something. It may be as simple as updating their file and maybe notifying the Department of Labor that they're doing that. And it may be that they need to file a new H-1B again, just update the location. It depends on what happens with it. But it's important for you guys to know this. These are the employer's responsibilities, not the employees. But I think it's important for you guys to know this, first of all, because I think the information is helpful, just to know what an employer has to do and what they have to be mindful of. But also because a lot of employers, if they're unfamiliar with this, is their first time doing something like this, or just if maybe their HR department that handled this in the past, people have left and now they have new people that are new to it. They may not know about these things, but when you see them happening, I think it's important to bring that up with somebody. It prevents a lot of headaches later on. So if you know this, even though it's not your responsibility, I think it's helpful for you to know. And I've seen some very proactive people that I've represented go to their employer and say, I think you have to do this. And then the employer says, no, I don't think I do. And then they call me, hey, do I have to do this? And I tell them, yes, they're right, you're wrong, you have to do this. And so we do it. But I want you guys to know this just so you're aware of it in case something comes up or you need to bring that up. One thing to keep in mind too, this may not necessarily apply to you guys at the stage you're at in life, but you can have a spouse and your dependent children in the United States with you on H-4 visas. One of the disappointing things, in my opinion, about the H-4 is that the spouse does not have authorization to work. And so, unfortunately, if you have a spouse accompanying you and they don't qualify for an H-1B or something else, they're not going to be allowed to work. They're allowed to be here with you, but they don't have the work authorization. So that's kind of a bummer, but it's something to know. One really great thing about this is the H-1B does allow for what we would call dual intent, meaning you intend to remain in the United States long term. So if any of you traveled and got student visas in your passport, you may have been required to show that you had the intent to return home when your studies were complete. And sometimes that can be a hard thing to do. Some people get denied student visas if the embassy or consulate they're at doesn't believe them or doesn't feel like they have enough information to show that. This doesn't require that at all. So you buy a house in the United States because you're employed in H-1B status, nobody cares. Nobody cares if it looks like you're trying to live here long term. The intent is not an issue anymore. So it's a very helpful thing for people because a lot of times if you think you might be working somewhere 3 to 6 years, you may want to buy a house. Or you may want to do things that look more permanent than what you would do if you're a student. So it's good to know that, that you don't have that same standard of having to show all these ties in the home country, all these things that you're going to go back to. They don't apply once you're in this status. It's really helpful. Another thing to keep in mind, we're not going to talk a lot about this today, but just so you guys are aware, you may be able to go more than 6 years in H-1B status if you have an employer who's assisted you in applying for permanent residency and you're at a certain stage of that process. It's complicated to even explain the process, so I don't want to confuse everybody and get too deep into this today. But the bottom line is, if you're in H-1B and your employer is interested in sponsoring you for permanent residence and you're in that process, at that point your employer's attorney is probably going to be working with you to see if you qualify for that extension of H-1B beyond the 6 years and what you need to do. So you may be able to be in the US longer than 6 years on H-1B, but the general rule is 6 years unless you've qualified for this exception. So I said a minute ago that the numerical limitation that we have on H-1Bs is one of the biggest topics that everybody talks about and is worried about and stresses out about and loses sleep at night. And so there are 65,000 H-1Bs available for people who have a bachelor's or its equivalent. And then there are another 20,000 available for people who have a US master's degree. And it's specifically a US conferred master's degree, not one that's equivalent to a US master's degree. So there's 85,000 each year. Not a lot. In many of the last 10 years, we've run out of H-1Bs in the first week that they become available. So we don't have enough. Unfortunately, our Congress does not want to increase the number because they think people might be taking US jobs. Well, I'm here to tell you I don't see that happening a lot because these are really expensive. So if you're going to do one, you really want that person, and that's it. Everybody that I've represented, it's not about I could hire someone in the US or I could hire this person. It's about this is the person. If I don't get this person, I don't want the job at all. So that's a bogus argument. That's just my 2 cents. But so we're, a lot of us are pretty frustrated with Congress, but they don't want to increase this number, so we're stuck here right now. So unless you've got an employer that happens to be exempt from these numerical limits, which I'll talk about in a second, they're going to be subject to this. The first day they can file is April 1st. Why? It's an arbitrary rule that the first day they can file is April 1st of the year. So what you want to do if you graduate from Trinity and you have one of these job offers and your employer says, yes, I want to do this H-1B petition for you, what you're going to want to do is be sure that you guys are working on it January, February, March, because it takes a good couple weeks at the least to put one together well. And you got to file it. You want it to get there on April 1st or as soon after that as you possibly can. Because if the numbers run out in that first week, and I thought I said this over here, but maybe I just dreamed it because I'm always thinking about these things. If the numbers run out in the first week, if tons of people apply and there's more than 85,000 that get there in the first week, what the Immigration Service will do is conduct a random lottery to select the ones that are going to get picked to be processed. So when you think about it, if you've got like the first 5 business days of April to file this thing, you want to get it in on April 1st or as soon as possible thereafter to have your best chance of being selected, because if it's filled in that first 5 business days, they're going to do a random selection. So you want to get it in there. You don't want to be waiting several days into April and take your chances. If it's not filled in the first 5 days, which has happened in the last few years, but if by chance it's not, I think it didn't in 2008 or 2009 because the economy was slower. If it doesn't fill up those first 5 days, they're just going to keep accepting H-1Bs until it is filled. And so in 08, when things really kind of slowed down, I think it was 08, maybe it was 09, we had H-1Bs available all the way through December because there just weren't that many employers who needed to file a lot of these. They were cutting back. So that was great for people who were late in finding job offers, but that found them. So that was really helpful. I don't know what's going to happen this year. We have a big slowdown where I live in Houston with the oil and gas industry going on right now, but I'm not sure that that's really going to translate over to other industries, so I don't know how it'll affect this year's cap. So my advice to everybody is if you've got the job offer and everything, you want to try and get it in at least April 1st or the first 5 business days to have your best chances. I did say a second ago there are employers that are exempt from this numerical limitation. They can always file. They don't ever have to worry about if there's one available. These are those employers. Institutions of higher education, like Trinity might be one of those. So you're working at a university like that, that would be an exempt employer. Nonprofit entities that are related to or affiliated with institutions of higher education, those usually can qualify to be exempt from the cap. Nonprofit research or governmental research organizations, those also are cap exempt employers. So if you think you are dealing with someone who qualifies for that exemption, you want to have them get to an attorney and talk about the exemption first, because if by chance they're not, and they just think they are, you still want to file in April, and the earliest in April that you possibly can. So there are specific regulations on what qualifies as an exempt employer and what doesn't. This is the general description. But if you're thinking your employer might be exempt, don't bank on that. Be sure you have someone analyze it first. And then if they really are, that's great. If not, you file first few days of April. Yes?
For the 20,000 spots or?
Good question. Okay, this is not, why do I not have an explanation of that here? I thought about it. I want to tell you guys that question is, if I have an MBA, am I just going to qualify to get one of these 20,000, or do I qualify to get any of these? If you have a U.S. master's degree, you could be counted in this 20, and if that's filled up, you drop into the 65,000 and could be counted there. So it's great to have a U.S. master's and apply for this because you get kind of 2 bites at the apple. You get the chance to qualify in this 20,000 U.S. master's cap, and if that's filled and you don't get selected, you're going to drop into the 65,000 regular cap, and you have a chance to be selected there. Okay. Application process. Again, this is something that mostly your employer, but you, to a lesser extent, are going to usually work with an attorney to do. I honestly do not recommend doing these on your own. There's a lot of DOL attestations, Department of Labor issues that come up with these. There is a whole fraud unit that is funded by the filing fees of these. I'm not kidding. And there are site visits by fraud investigators, and I think it's really good to work with someone who knows what you need to have and do and have with you in your file that your employer keeps so that you don't have a problem with this later on. Prevention is always better than cure later. That's a general rule in my field. So I want you to know about this application process again so you are aware of this. As I said, it requires a sponsoring employer. Self-sponsoring is not an option except if you own part of a company and you can show that another person has a controlling interest in the company, then that company might be able to sponsor you. But what generally will not be allowed to take place is if you open your own company, it's all yours, and you're going to file an H-1B for yourself. That's when I say self-sponsoring, that's what I mean, and that is not something that's going to be allowed in H-1B. There are other visas that may allow for that. I'll talk about those a little bit later. H-1B is not going to allow for that. You have to have a sponsoring employer. You're not sponsoring yourself. As I said, the employer is going to complete the required documentation. They're going to file on April 1st or as soon as possible thereafter. If the cap's reached within the first 5 business days of April, there's going to be a lottery to randomly select the petitions that get chosen for the cap. Yes?
So does it mean that if my company files it with early April 1st, does it mean that I'm safe? Or
it means that if in the first 5 business days of April there are more than 65,000 in the regular cap,
that's possible?
it's still possible that you may not be selected. You have your best chance of being selected if you file on April 1st or the first 5 business days of April. And that's my recommendation. But if there are that many people applying, more than the available number, you still may not get selected. And that's why I was mentioning, I mentioned earlier, if the cap isn't reached in the first 5 business days, they'll keep accepting H-1Bs until it is. But if it is reached, everybody that applied in the first 5 days is going to get put in basically in a big bowl and pulled out. And so you could be selected in that, or you may not.
And my second question is that I will be working with this company, and then say if I don't get it this April, is it possible to do the same thing next April? Because technically I graduated in May and I still have 1 more month, right? So April 2016.
Right. It is. What I would say is you want to be sure if you're filing your H-1B. So the question is if you try to file this year and you don't get selected, could you do it again next year? There's no prohibition on the number of times you try to do this. So it doesn't matter how many times you need to try. You can. One thing you want to watch for is if you don't actually have the degree in your hand, but you've completed all the requirements for the degree, usually your departmental advisor or an official from your school can prepare a letter confirming that you've completed all the requirements for your degree, and we need that to show to immigration that your degree is complete. If you have not walked the stage, if you do not yet have the degree, that date hasn't arrived, but you're going to go ahead and apply now. So that's something. I'm sorry? That is possible, and it's the school's determination. I mean, if the school can certify that you have completed the requirements for your degree, then yes. If you have not yet in April, if that is not possible, because it may not be, I guess it depends on the program of study and how far along you are in it. But if that's not possible for the school to do, and you have not technically completed your degree, you have to have done so when you file this. So what you may need to do is complete your degree, get your post-completion OPT, use it, and then have your employer file next April. If that's your situation, that's what you would do, and try that. And then if you are selected, great. If you're not, and you qualify for the 17-month OPT extension, you may need to do that. If not, you may need to look at some other options. And I'll talk about a few of those in a little bit, but on a general level. So that's what I would say about that, is if you have not yet completed the degree, this is not something you want to do yet. You need to have completed it, and even if it's a situation where your graduation ceremony hasn't taken place, but your school can authorize that you've completed your degree requirements, that is okay. If you have not yet, as of April 1st, you can try to wait and see if the cap does not get met and visas are still available in May or June, and then try. That's another option if it really is slow this year and we don't run out in April and they keep going for May, that may be an option too. So be sure and watch to see if the cap's filled.
The time is interesting because students graduate in May.
Yes.
The date is April.
Yes.
1 month before
I agree, it's weird. And the reason it's April 1st, it's an arbitrary date, but it's an arbitrary date that happens to be 6 months before the beginning of a fiscal year. You know, the fiscal year starts October 1st, and the idea is you're applying 6 months out. You actually get to begin working on October 1st, and so they put this 6-month gap, and that's where I don't know if it makes sense for employers. I think it's kind of inconvenient, but that's the world we live in. So yeah, the timing is not great, but it's what we have to do, so we deal. Yes? Mm-hmm.
Partnership and your partner has 50 or more % of the company, can that company, even though you have like 49%, for example,
Yeah.
it still sponsor you for an H-1B? Or are there certain requirements that the company must have, such as, I don't know, a bank account should show certain numbers or certain employees in the company, stuff like that?
I have actually had this situation a couple years ago, and so the question is, since you can't self-sponsor, what if you own 49% of a business that you start after you graduate, and you don't own a majority of it? Could you be sponsored for an H-1B? I did file one of those for someone a couple of years ago, and the Immigration Service denied the petition, but not because they felt he was sponsoring himself. Their issue was it was a 2-person company, and they said, we don't believe the work you're going to be doing is requiring a degree. We think you're going to sweep the floors, operate the cash register, do everything. And that's not specialty occupation work. Sounds kind of mean, right? You got to start a business somewhere. I mean, I have my own business. I can attest to that. Just because I opened just with me didn't mean I wasn't an attorney doing attorney work. So I don't think that's necessarily fair. And I don't think that particular situation means that that is not possible, especially because they didn't question that the ownership structure and whether it was. What they said was, we want to be sure it's a real job opportunity that you have, and we, presented all this evidence of his experience with this subject and his 2 degrees in architecture and his experience working with this gentleman that he was partnering with. But for them, it came down to specialty occupation and believing that he really was going to do professional level work and not more, his architecture background, I think they felt he was more going to have a home renovation business than an architectural consulting business. So I have seen it be done where someone has some ownership interest and it still can work, but because when you're a new company, you tend to be small, you have to watch for other issues that come into play, like are you really going to be doing work that requires a degree or not? And can the company pay the wage that they're attesting to for the Department of Labor? Remember, there's a wage attestation from the employer, and if there's a question as to whether the company can pay that could be an issue too. So other things to keep in mind. But I would say it's possible. I would say that's especially one you need an experienced attorney to work with you on. You don't want to, that's one that it is a lot harder to get it done if you've been denied once and you try to go back and do it again. You want to get it right the first time if it is at all possible. So that's, yes, Bob?
We're supposed to go to 12:30, but if Kathryn is willing, you can go longer.
I'm okay, because
we just have to leave here by no later than 5 till 1.
No problem. So let me
So if
continue.
you'd like to stay longer and ask more questions, that's fine.
Yeah, let me continue telling you guys about this, and then if there's Q&A and we don't have time for that because of time limitations, my cards and things are at the International Student Office, and my website is at the end of this presentation too. So we were talking about the numerical limitation, and if you're selected, one thing I want y'all to be sure and understand is that Just because you're selected for the cap doesn't mean your petition's going to be approved. So my architecture person I was just talking about, his petition was selected for the cap, and it continued to be processed, but it was ultimately denied because they didn't believe he qualified. So remember, you have a couple of hurdles to get through here. You get selected for the $65,000 or the $20,000 if you have a U.S. master's. And then once you do that, the Immigration Service is going to decide if the petition should be approved or not. So there's 2 hurdles you want to get through. So just keep that in mind. Cap gap OPT. We used to have a problem several years ago when people would complete their degree and they'd get their post-completion OPT, employment authorization. Maybe it would expire in June of a year, and the H-1B actually begins, the employment begins October 1st. Remember, it's the beginning of the fiscal year that it starts. So what happens between June and October? Back in the day, a person would go home and wait, which is not very efficient, especially if you're an employer and you need this person around. So luckily now, the Immigration Service is allowing people to get their OPT extended to cover that gap between its expiration and the start of the H-1B. There are some specific procedures for how to document that. There is usually a new I-20 issued. There is a new I-20 issued once your H-1B is selected. And if your H-1B is approved, there's another I-20 issued. There are guidelines on it, about it on the uscis.gov website, but you want to be sure and do that. It's not an automatic extension. You need to work with your international office to get that done. If your H-1B is approved, as I mentioned, if it's receipted in, there's an extension for a month or 2 to allow the service to try to make a decision on it. If it's approved, they're going to extend your post-completion OPT through September 30th so that you can have status up through September 30th and your H-1B beginning on October 1st so that you are covered. You don't have to go home and wait. That's what this is for. Okay, I'm going to leave this for a second just to say that there are very specific circumstances in which you might be able to travel or not during this cap gap period. It's really important to check the CIS website. It's also really important to talk to whatever attorney you're working with on your H-1B. Don't assume you're okay to travel and then find out you were not and run into a problem later on. Because if you do get your H-1B selected for approval, even though it's been approved, again, it's the earliest it's going to begin is October 1st. So if it's July and you've traveled and now you cannot re-enter on your current visa, your consulate is going to give you an H-1B visa that's valid September 30th or 20th, maybe a week or 2 before October 1st to give you time to get here. And so from July to September, you're stuck. So be sure you check with someone before you make your decisions to travel during that period, because there are specific things you're going to need to carry if you do, and you may not have them, and that's an issue, so you need to be aware of it. As I said, there are some other options besides H-1B that you may or may not qualify for. I want to mention that there are, just so everybody knows, that is not the only visa that you may consider applying for. We have L1 visas, and these are for people who are working somewhere at a company overseas, and that company is seeking to transfer them in to a US branch. So if by chance you complete this degree, you do your post-completion OPT, you can't find anything here, you end up working at a multinational company or a company that just has multiple branches around the world, and after a year there they say, we'd like to move you back to the US, that might be possible. So that's one option you have. I know that may not be the ideal option for everybody, but it is an option, so keep that in mind. For anybody who's national of Canada or Mexico, we have TN visas. They're similar to H-1Bs in that they're intended for professional occupations, but the TN has a specific list of occupations that qualify for it, so you want to be sure and check with your attorney on that. But TN is great. There's no limit on the number of times you can get TN, so unlike H-1B where you have a 6-year limit, for anybody who qualifies for this, you can continue to renew it as long as you qualify, so that's really good. O1 is for individuals who have extraordinary ability in arts, sciences, or business. Generally, we want to show awards and publications and things like that, but my office has done some unusual O1s, so you're not necessarily limited to academic things to evidence your extraordinary ability, but that's one thing. E2s, if you're from an E2 treaty country and you want to invest and open a business here, or there is an E2 treaty investor here who wants to hire you as a key employee or manager, you may qualify for that. You can Google E2 treaty country list and see if your home country is on it. If it's not, this is not available to you. If you're a dual national, either one of your nationalities is on the list. You have this available to you. E2s get pretty complicated. This is another one. I would never recommend someone try this on their own, but it's there, and I want you to be aware that there is something there. How many of you guys heard about this DACA program that came out in 2012? This is the program that came out for people who entered the United States before they were 16, who were undocumented. This is a program the executive branch of the US government announced that was intended to help people who'd come at a very young age without status to remain in the United States and have work authorization. That program got extended recently. So I was going to talk about what you had to do back then to apply and to qualify and what you have to have now. But since we're running short on time, I want to have a little time in case anybody has other questions. This is what people need to do to qualify for this. So if you happen to know anyone who's an undocumented student or young person in the community, as of the date they filed the application, instead of showing they were here since June 15th of 07, it's been moved up to January 1st of 2010. That was done to make this available to more people, because there were a lot of people who weren't here since 07, but they were here since 2010. Also, there used to be a cap on their age. As of June 15, 2012, when this program was originally announced, a person had to be under 31 to qualify, but they removed the age cap because there were some people who were over 31 at that time, but they still got here when they were under 16 and met all these other things. So if anybody thinks they qualify for this, again, checking with a reputable attorney, you can figure this out pretty quickly. But if a person puts their application for this out and they don't qualify, they're pretty much outing themselves to immigration as someone without status. So you have to be careful on this, and I've seen enough people do that and not know that they don't qualify. And it's a real shame when somebody does that. So checking and being sure that a person qualifies is really important in a situation like this in particular. I'm going to skip over the benefits of that program. I don't know if any of this is going to apply to any of you guys or anyone you know, but there are other things. If you are afraid to return to your home country because you think you may be persecuted because of your race, your religion, your national origin, a political opinion, or a social group that you belong to, and social group is pretty broad, that is an option. It's not something that's easy. It's not something that everybody just gets. But if that really is a real concern to you or someone you know, that's something to be aware of. We also have the Violence Against Women Act. It's not just for women. It's called that, but I've had 2 male Violence Against Women Act applicants who've won their cases, but these are for people who are married to or had reason to believe they were married to someone and maybe the marriage had a legal technical issue that it wasn't valid, but they're married to someone who has battered them physically or subjected them to extreme cruelty emotionally or socially. And this allows somebody, provided the person that they were married to is a US citizen or permanent resident, this allows that person to self-sponsor. This is one of those rare circumstances where a person can do that. And I mention this only because I know a lot of bright young people who, in the course of being in the United States, meet someone and they marry and something goes wrong, and I'm always surprised when it's a professional. I've had 2 doctors, I've had a lot of intelligent people. It's not about intelligence. This situation can happen, and I want to be sure people know about it because you don't have to stay with someone who's abusing you. Getting the right documentation together is important, but I want to be sure everybody knows this. I represent so many people who leave abusive relationships, and it's important for me to convey that to you guys. And then also, we do have a U visa in the United States. This is basically for victims of a crime that occurred in the US. There is a law enforcement certification that you're going to be helpful in their investigation, or you have been, or you are being helpful right now. But the U visa is great. It gives you 4 years, and after the 3rd year, you can apply for permanent residence because you are a U visa holder. So it's another kind of self-sponsoring type situation. If anybody's a victim of a crime, it's really important for them to know that this is out there and to contact law enforcement. You know, that is really important. There's a lot of people who are afraid to do that, but it's important for people to know about this program. So when I was getting ready to come here and talk to you guys, Stephanie from the International Students Office told me, I said, okay, here's a presentation, Stephanie. It was basically all that minus this page. She said, this is great, Katie, but a lot of what the students ask me is, how do I get a green card? And I said, oh, okay. I was too afraid of like overwhelming everybody with info, but you know, you guys go to Trinity, you're getting a lot of info every day, and you're not dead, so you can hear about this. Generally, if you're going to apply for a green card, the general rule is you need an employer or a family member that's going to sponsor you. but that is not an absolute rule. Probably for you guys, a lot of you, if you end up pursuing a green card, it's going to happen either because you got a job offer and the employer was interested in going this route, or in the course of living and working in the US, you end up meeting someone. That happens for a lot of young people who are of marriageable age. That being said, I have enough intelligent people who come to me and say, well, why don't I just marry someone? And I tell them, no, bad idea. And they say, well, why not? And I tell them, well, I can't explain exactly how it happens, but every single time someone does that, immigration hates the case and denies it, and everybody gets into this big mess. And once you've been accused and the Immigration Service makes a determination that you've committed marriage fraud, nobody can sponsor you ever again. So it kind of kills your opportunity to do anything legit, so don't do that. But, you know, a lot of people, just because they're here and it's time in your life to think about things like that, you meet someone, that happens. So that's something that happens for people who are young professionals that are out and about meeting people. But if that doesn't happen, you know, I mentioned before, there's the U visa, there's political asylum. If you're in a relationship or a situation where that includes violence or cruelty, you might have a Violence Against Women Act situation. But outside of that, there are 2 work-related ways to self-sponsor, and I want to be sure and hit those before we close up for the day. There is an extraordinary ability petition for someone who has risen to the very top of their field of endeavor. Generally, a bachelor's level graduate is not going to qualify for this. We have to show a few different things. It could be awards or publications about you and your work, publications that you have about what you're doing. There are a few different ways to document it. It could be in the arts. It could be success with your art or your field. I had a restaurant owner who was able to, he had a successful chain in another country and he was able to start opening it here. So it's not just limited to academic fields. It can be business as well. This gets pretty complicated. You should definitely have a consultation with an attorney to talk about how strong your case is. When you're looking at this, I think that's very helpful. I can generally spend an hour to an hour and a half with someone and figure out where the strengths and weaknesses are and tell them what I think we need to do if they want to go that route. There's also the other self-sponsoring work-based petition is the National Interest Waiver petition. For this, you need to show that you either have the equivalent of a master's or a bachelor's and 5 years of experience in your field. So this may be something that you look at in a few years, but a lot of people are interested in this one because the standard of achievement is a little bit lower than extraordinary ability. You don't have to show quite as much. But what you do want to show is that your work is national in scope and it has an impact, meaning it has an impact throughout the United States, that it's in the US national interest for you to remain here and continue in your field, and that a person who would otherwise be minimally qualified to do the work you're doing would not have the impact that you have. And that's where a lot of our creativity and our documentation really comes into play, showing that whatever you're doing and whatever you're able to do is a lot more than what someone who would be minimally qualified to take your job could do. But that being said, it doesn't require a sponsoring employer. You can be working somewhere and the employer is not involved in this. It's just showing that your work has that quality. And so that's a very attractive one for some people where their employer says, I cannot get involved in this, I don't want to, I don't have the resources, I don't have the time. These are the types of things people start looking at in that situation. So I want you guys to know about that. You'll hear more and more about it as you go on in years, but that's the beginnings of it. Okay, so last minute caveats, of course. I know it's easy for me to stand up here and say, go see an attorney, because that's what I do for a living, right? But I say that because it's really, really hard for me when someone comes in and it's like, I don't know who they went and talked to, or maybe they didn't talk to anybody at all, and they've spent money and they've spent time, and they're going through emotional distress about this situation, and I'm going, wow, I wish I'd met you before, because I would have done this totally differently, and I don't think we'd be here right now. And it happens a lot. So I don't care if it's me or anybody else. When you're going through these things, start with a consultation with an attorney. A little tiny bit of money can take you a long way in terms of understanding what you can do. And I'm talking like $100, maybe $200. You can sit with an attorney for an hour and figure out what you can do. And in terms of how much it affects your future, that's a very small amount of money to know what to do and what you can expect, whether you like that attorney or not, whether you hire them or not. I see so many people who should have done that in the first place that I always want to, whenever I'm presenting to people, I want to tell them that. I also want to mention, because these executive actions just were announced in November, the program for undocumented people, those are some of them are just starting and some of them haven't started. So please be careful. Anybody who's thinking of applying for that you know, be sure that they check with someone before they apply, because there are scammers out there, so you want to be careful. And then, again, my general rule, it's always better to get a petition or an application right the first time than to have to get a denial and revisit it later. I can get those done. That's a specialty at my office, to take a denied petition and refile it and get it approved. But it's not easy, and it's not cheap. It's a lot easier to just do it right the first time. So you need advice. Of course, my office is there. There are offices around here too, but be sure and try to do things right the first time.
I just wanted to mention along those lines.
Yes.
I see this a lot, where people will just go to an attorney.
Yes, good
And
point.
that's a real bad thing to do. They'll say, oh, my brother's an attorney, he can do that for you, but he may not
Good
even
point.
be familiar with immigration law.
This
and
is
he may
not-
not be board certified. So
This is not the kind of thing that you want to talk to your friend who does real estate law. This is a whole, most people who are reputable in this field, this is all they do, because it's so complicated. You really got to focus on it and nothing else. So this is not where you want to go to your uncle who's a divorce attorney, or don't do that. And don't go to someone who's, I'm a notario. I don't know if that happens a lot around here, but in Houston there are people who say, well, I'm a notario. Well, in Mexico, apparently those are attorneys and maybe more. They have a lot of responsibility. Here, a notary is a person who verifies your ID and that you are the person who signs something and says, okay, ID verified, this is the person who signed. That's what they do here, that's it. They don't have legal training. So you gotta watch out. You wanna be sure it's someone who's a licensed attorney who practices immigration, because anybody else, it's hard to, it took me 7 years to be where I am in my practice. It's hard to learn this, there's a steep learning curve. So be sure you're dealing with someone who's in this field. Thank you for that point. Okay, so that I know is a lot of info in a short amount of time. I never made this presentation with the intention for you guys to memorize all this. I can't even memorize all of it. I just know exactly where I need to go to find all the info I need. But I want to tell you about this to give you an idea of what you're looking at in terms of your options. When these issues come up, that's the time to reach out to someone and talk to them about it. And so this is, I wanted to give you guys an overview of some different options. This is my firm's website. This is our informational email that you can send an email to if you have a question and you want to see if you can talk to somebody about it. Our office number. You know, of course, in the immediate future, you may have OPT, CPT, or H-1B issues that you want to speak about. Later on down the line, it could be something totally different. We do all of it. We don't specialize in just students or just employment-based or just family immigration. We can do the whole range, so it doesn't really matter to me what it is. But you guys can always reach out to us. And, you know, I think that it's really good that you're at a school with an international office that cares about what you do and that's aiming to go broader and broader in the international community. I think it's really great. So, of course, if my office can help you in the future, we're happy to. But, you know, I really wish you guys the best of luck. I look back on my Trinity years and enjoy them so much. I hope you guys do too. So, any questions we didn't hit already? Yes?
I actually have a few questions for you,
Okay.
if you don't mind.
How are we doing on time, Bob?
Oh, we're fine on time.
Okay.
If you have an appointment, though, this afternoon, then you could ask those questions then. Unless you don't have an appointment, then go ahead and ask the questions.
And those of you guys, I know you may be heading to another class. If you need to head out, that's fine too. But go ahead.
Okay, so the first question is, CPT and OPT are also offered in graduate programs, right?
I believe so. I don't think
Yeah,
it's,
for all,
yeah.
any degree,
Yeah,
you
they are.
get 1 year. Any degree.
The second question was in regard to the transition from OPT to H-1B and H-1B to green card. How does that work? Is that something that people usually do after they get sponsored their H-1B, they go straight to green card, or how does that work?
It depends on it's really circumstance specific. So, you know, if someone goes from OPT to H-1B, that's not a long, intensive process. It can take 2, 3, 4 months of preparation and waiting. It may take up to 6 or 8 months of preparation and waiting, depending on, depending on how things go. But then the transition from H-1B to green card can take longer because depending on what your position is, what your qualifications are, your employer, depending on a lot of different facts in that situation, your employer might go one route or another, and depending on what it is, it might be something that takes 3 or 4 years. It may be something that takes longer than that. Unfortunately, for nationals of India and China right now, there's a huge backlog in the wait for green cards. So there's a lot of people in line for a green card that just don't have one in their hand. That's another thing that it would be nice if our Congress would increase the numbers and then everybody would just get them and move on. But since they haven't done that yet, we're kind of sitting waiting. So it's hard to answer it without knowing the circumstances, but what I would say is that when you're on OPT and you know you want to make that transition to H-1B, that's a time to meet with an attorney, talk to your employer and get them to meet with an attorney about it. When you've got the H-1B or whatever else you may do, and you know you want to try for the green card and you're wondering how to do that, that's another time. Meet with an attorney, talk to him about what you qualify for, because again, it's hard, it's always hard to watch when people start doing that and then there are problems and I say, oh gosh, you never should have done this, this isn't going to work, we have to do something else. It's easier to figure that out at the beginning. So when you're at the beginning of those points where you're thinking, I know I want to go to this, that's the time to start looking at it. It's not too early. It's okay to start thinking about it right then and talking to somebody about it. But the transition can go a few different directions.
Because the H-1B can only be renewed twice, right?
Yes, unless you're in the green card process at a certain point, yeah.
Okay, and then after the 6th year, what happens then? Usually people get the green card or people just go back to the...
Good question. Unfortunately, if people don't have the green card process in place and they're not allowed to remain here longer, some people do have to leave. And it's really upsetting, as you can imagine, for some people, especially if they thought their employer was going to do something and it didn't happen. And sometimes it happens, sometimes you have a well-intentioned employer who finds out they can't afford to do this after all, or they tried and things were denied for legitimate reasons that we just can't get past. So with knowing that and then how disruptive it is for a person who's been here for several years, it's important for employers to try to start that green card process as soon as they're ready. It's always easier the earlier in the H-1B period they are. But yeah, some people do have to leave the U.S. and go home, and it's very upsetting when I have to see that happen. There's not really a grace period or an exception if the green card process doesn't work out and there's no other family-based option or anything like that that comes up. So that does happen. So.
Was in regards to the J1 and H3 training visas.
Yes, we didn't talk about those today.
After the OPT, or and how long do they last usually?
You can, and I'll just say briefly, J1 and H3 visas are often used for trainees. J1 has some other uses as well. It could be sometimes other professionals that use it for different reasons. And a lot of times you have to be careful with a J1 program if it may subject you to a requirement to return to your home country for 2 years. And so if you're looking at any kind of J1 program, that's another time, talk to an attorney about it and be sure you're not going to be promising to go back to your home country for 2 years or having to file some kind of waiver of that requirement, because that can get tricky. But when you're using J1 or H3 for trainee programs, generally speaking, the employer starts documenting their training program if they don't already have it documented. There is a third party, I can't think of the name of these companies, but there are third-party companies that will come inspect the employer's site, verify the training program, give it their certification, and then the attorney or the employer, whoever, will take everything and file it with immigration. And so that's how that works. But you have to keep in mind, I've seen people get into some problem situations with those because, again, they're trainees programs. It's not for productive employment. The idea is you're getting trained on something so you can go use it somewhere else. And so if there's a determination that you have a productive employment situation and not just training, you could be required to leave the US, your status could be revoked. You could be coming back from an international trip and be stopped at the airport and questioned about it. There's a few different ways that can come up. But that's one thing I think that, because I think, again, there are a lot of well-intentioned employers who think, well, if I can't keep this person here as an employee, I'll come up with some kind of training program and we'll just do that. And the intention is good, but they have to be careful about that part, because productive employment in that circumstance is only supposed to happen as required to train you for something. So where you come in and you show up at your desk and you're working all day, that's not training. So the employers have to be careful about that. That's, you know, that's part of why there's the requirement that the third-party organization, not the requirement, but that you typically have a third-party organization come in and go over your training program and certify it first. So that's a really quick overview of those.
Work with a trainee visa, you're just here to learn pretty much?
You can be, if you're on, for example, a foreign company's payroll and they're sending you here for training, without having regulations in front of me to check, I think you may be able to receive compensation in your home country as a continued employee there. But yeah, here, you're not here to earn money, you're not here to work, you're here to train on something. And like I said, with J1 in particular, you really have to be careful about if you are subject to a 2-year return requirement, you might have to go to your home country for 2 years before you can immigrate to the United States or change to H-1B or something else. So talking to somebody about that before you go forward with it is a really good idea. Anybody else with any other questions? Yes?
Is there a database of employees that you e-verify?
I don't think, gosh, is there? I don't think so, because it's not a requirement here. I think that it is something that if you're speaking with an employer about employment opportunities, you can probably just ask them, do you use the E-Verify program? If they don't, you know, employers can sign up for it. A lot of attorneys would advise them not to because it's opening up a lot of their information to the US government scrutiny. And even if they didn't mean to do anything wrong, sometimes there's something wrong there and they get in trouble. So a lot of attorneys are going to advise employers not to unless they have to. But they can enroll in it. And as I said too, some employers have multiple offices, and in states where it's required, they may have, if they have an office there, that's an obvious choice as far as like a STEM OPT extension that's going to require the E-Verify. So, but I don't think so. I can double check that, but I don't think there is. Yeah? Well, you're welcome, thanks for coming. After a PhD program, if you're completing F1, your F1 studies, I would say that if it's possible for you to get the H-1B, you want to do that first. Because generally speaking, it's very hard for anyone to go from a status that requires intent to return home straight to applying for a green card. There kind of is a conflict in those two ideas. But also, to qualify to apply for your green card here without leaving the US, you want to show that you're in a valid status. So if you complete your study, having H-1B status for the next 3 years, you're covered for 3 years. And so I would advise anyone to go for the H-1B first and then look at your green card options, and you will have time to do it. Absolutely, yeah. Okay, well thanks guys, thanks for coming. I know it was a lot of info in a short amount of time. I hope it was helpful.